Liens come up in a variety of contexts, not just in construction, and learn some about this in personal property. There are mechanics liens, there are attorney's liens. A lot of people have common law type lien rights, which basically are rights against specific property. And the way they come up in the context of construction is in the way that different statutes around the country, both in the United States and in Canada, address the rights of subcontractors and suppliers to get paid by having lien rights by statute against the real property that's being improved. So if we look at the Michigan Construction Lien Act, and in Michigan, obviously, they're called construction liens. Some places are called mechanics liens. These vary from state to state, and it's kind of a science unto itself. There are law firms that specialize just in lien work or do a lot of lien work, and it's important to get somebody who really knows what they're doing because there are a lot of very specific notice requirements that have to be met in order to perfect a lien. But if you cross all the T's and dot all the I's properly, this can be an extremely valuable right that subcontractors and suppliers have. So, for example, under the Michigan Construction Lien Act, contractors, subcontractors, suppliers, or laborers, right, anybody who's essentially below the level of the owner who provides an improvement to the real property has a lien on the interest of the owner or the lessee who contracted for the improvement to the real property. Now, the reference to a notice of commencement just refers to notice that the owner has to give in the public records to show that there is work that's being done. It's to put everyone on notice that it's possible that there could be liens on the property. And if we skip over a lot of the specifics in terms of how these liens are perfected, when they're the different notice requirements, because the contractors, subcontractors, etc., have to supply notice of furnishing of labor and materials. There are different steps, as I say, that have to be taken in order to perfect a lien. But once all those are done, kind of the ultimate weapon is if the lien is perfected, the lien holder can foreclose the lien in the same way that a bank can foreclose a mortgage. And that's what this section of the Lien Act is about, is that the lien holder, the lien claimant, can go to court, and if the lien claimant has crossed all the T's, dotted all the I's, and the amount still hasn't been paid, then ultimately the court can order sale of the real property in order to satisfy the lien. So this is not an insignificant right that subcontractors and suppliers have. Now, as a practical matter, what would usually happen is that either there will be a payment bond that the owner has required the contractor to furnish, which will ensure that lien claimants get paid. And we've talked about payment bonds before. Or if there isn't already a payment bond on the project, the owner will require a contractor to, quote, bond off the liens, because these liens create obviously a cloud on the title, and that's a problem as far as the owner. So liens create a headache for owners in that they represent clouds on the title. And in fact, one of the potential downsides that lien claimants have to be aware of in filing liens on properties, if they don't have valid claims, by filing a lien, they may expose themselves to a claim of slander of title, which of course is its own action that an owner could assert against a lien claimant, saying, hey, you've clouded my title, you've slandered my title by filing this lien when you didn't have any basis for doing so. So there are some downsides, potential downsides as well, but it's important to understand that subs and suppliers have these lien rights. This also explains why in the payment process you'll see references to the contractor having to supply lien waivers along with its pay application. Essentially, the contractor saying to the owner, I have paid all the subs and suppliers that are owed any money, and therefore here are waivers that they're signing to show that they've been paid so that they won't be filing liens against your property, and owners will require lien waivers from subcontractors and suppliers and the contractor itself to ensure that liens don't get filed on the property. Now in Ontario, the Construction Act, which used to be the Construction Lien Act, basically says a lot of the same kinds of things as you see in Michigan. Here you've got a person supplying services or materials for an improvement has a lien upon the interest of the owner of the property that's being improved. And again, this is very much a state by state or province by province kind of thing, and so it's important to read the lien statute in each jurisdiction to understand exactly who has lien rights. For example, do architects, do they have lien rights? Well, in Michigan they do, under a separate section of the Construction Lien Act. And so it's important, depending on who's asserting a lien, to understand, do they have a right to assert a lien in the first place? Now, one kind of wrinkle to the Ontario statute that's worth pointing out is that the lien represents a charge upon the holdback. Now, you'll remember when we were talking about the payment process earlier, I talked about holdback, and holdback is something that's not really a thing in the United States. Holdback under the Ontario Construction Act is essentially money that the owner is holding back from payments to the contractor, not as security for the contractor's future performance. That's retainage, which the owner may also be holding on the contractor. But holdback is different because it's designed to protect not the owner, but rather the subcontractors and suppliers. So it's a pot of money that functions in a way like a payment bond. It's a pot of money that the owner is holding back in order to satisfy potential claims of subcontractors and suppliers. And so this section of the Ontario Construction Act just makes it clear that the lien represents a charge on that pot of money that the owner is holding by way of, quote, holdback. Okay, but at the same time, the lien's also, like in Michigan, a charge on the real property. And if push comes to shove, the court, in the process of foreclosing a lien, ultimately can order that the land be sold in order to satisfy the lien claimants. So again, this is a very important right that subs and suppliers and others, even the contractor itself, have in order to ensure that they get paid. So construction liens or mechanics liens, the lingo varies from place to place, but the concept is the same. Unpaid subs and suppliers have by statute rights against the real property, and by giving the subs and suppliers and contractors rights against the real property, it brings the owner kind of to the table to make sure that these people are getting paid, because after all, it's the owner whose property ultimately is being improved.